Evening.
Hi there, Terzal, Mohammed, Mr. Van Rienen, Chadley, Jay, Naidu, and I see Bronwyn is here this evening.
How are you, Mr. Alom?
I'm okay, thank you. Well, going on. How about you?
No, all good, all good. I'm just checking
Lovely.
in on you to check that the recording is there and
Uh,
you can go ahead. I'm going to leave you. You've got my WhatsApp number if you need me for anything.
Thank you very much.
Okay, Dal will be back in the session at about 6.
Okay, that's
Okay,
fantastic.
enjoy.
Will
Bye.
do. Thank you. Bye. So, good evening, everybody. Are there any newcomers to our session? Who's here for the first time? No one's, also everybody's been here before. I mean, that's a good thing. So this evening, what we're going to do is we'll focus a bit on unfair dismissals. You know, we haven't formally focused on it. We're always mentioning things in passing. And about dismissals. So this evening, what I'm going to do is I am going to just formally go through it. Okay. And it's part of the routine, it's part of the, you know, the way that you should actually approach this course, guys, is that, as I've mentioned to those who've been here before, that, you know, piece by piece or piecemeal doing the course, you know, has got its disadvantages. It's sometimes a better idea to actually go through everything as many times as you can, you know. So some people use the approach that they break the work up into certain workable parts which they hope to complete, you know, over the semester. And eventually, if there's enough time left, then they use that for the but what I found is that, you know, you can't always, with that approach, prepare for a situation that if you don't make it through or something happens or, you know, where you're left with, you don't have enough time or you don't, you know, something beyond your control happens and now you haven't finished everything. You don't know what the end of the course is about. You know? So that can be a problem. So let me just see, where is my task? I had it here a second ago. I'm gonna get it again here. All right, here we go. That's not the one I wanted. There's another one I wanted actually. Okay, yes. Can you guys please put your student numbers in the chat box? You know, you don't, there's no formal register, but you simply put in your student number in the chat box. So if you guys can see the screen that I've shared with you now, it's a little question, a discussion question for us. Can you all see that? If you can, just raise your hand. Okay, just only Okay, one, two, few people. Okay, good. Okay, fantastic. So let's do it. Here's a little discussion on unfair dismissals and terminations of contracts, because that is what unfair, well, not unfair, but that's what a dismissal actually means in labor law. It signifies termination of a contract. And as we know, that contracts can be terminated. Contracts are obligations, they're legal bonds, which the law attaches consequences to. But one has sometimes the right in certain circumstances to end the contract. How do you end the contract of marriage, by the way? Is marriage not a contract? It is. It's a very specific contract of which it's become a study on its own. And there's very particular rules how you cancel that contract. All right? In fact, you need a court order and you need to institute divorce proceedings. And there's a law that's created simply to deal with those particular issues there in a marriage and in divorce. A sale contract, also can be terminated in certain instances. Okay, so the obligations that are there by law can be terminated. So in a similar manner, the employment contract also has a way of, has its own rules of cancellation and termination. Right? So dismissal is examination on that aspect of how the employment contract may come to an end. There's other ways an employment contract comes to an end. Dismissal shows how, from an employer's point of view, the contract may be ended. Contract can also be ended from the employee's point of view, from the employee's side, if the employee were to resign. Okay, so let us look at this question. Jack is employed as a male nurse at the local hospital, where he likes to frequent a nearby bar each night after his shift. However, Jack has been arriving at work severely hungover, still intoxicated from the previous night. After numerous complaints from patients and warnings from his employer, Jack is fired. The hospital's code of conduct granted each employee the right to appear before a disciplinary board before they are dismissed. Each employee then has the chance to plead their case before the board. Do you think Jack's employer had a fair reason to dismiss him? Hear your thoughts, guys. Was it fair of the employer to dismiss, or do they have a fair reason to dismiss Jack?
Wouldn't it depend on what his contractual obligation of his employment states? So,
can you elaborate?
Okay, say for instance, his contract says that he's supposed to be able to work in a capacity where he is not, where he's sober and, all of that. So maybe his conduct, maybe he didn't necessarily, his conduct was fine at the workplace, because they don't exactly tell you how he's working. They just say that he comes to work hungover. But they don't say whether that actually affects his capacity and his conduct as a male nurse. Mm-hmm. But I'm assuming that maybe his contract as a male nurse at a specific hospital might actually say that you need to be specifically looking at the type of work he's doing as a male nurse. I don't think that, practically, I don't think being hungover is exactly something you should be. So that's why I'm saying, shouldn't it be, you have to look maybe at the contract. What does the contract say? What was his conduct and capacity as a male nurse during his hungover state? Was it, that kind of thing? The fact that maybe he had complaints from patients and warnings from his employer, kind of gives you that idea. But yeah, but that's basically that's my thought process currently.
No, it's brilliant. That's good. That's definitely, look, the first thing you need to look at is whether in any dismissal matter, okay, in any matter where dismissal arises, we're reaching now the end of the employment contract, right, where the employer is dismissing you. But it's always good to examine your employment contract and see what it says. Okay. Because we know one of the rights that you have as an employee under the labor laws, we went through a couple of things. You have the right to certain basic conditions of employment. You have the right not to be unlawfully discriminated against on certain grounds and even unspecified grounds. You have the right to enjoy fair labor practices, not unfair labor practices. Not to be overlooked when there's a benefit that's going to all the workers and for some reason you are excluded. There's so many protections. So at the end, when it comes to dismissal, you have the right not to be unfairly dismissed. The right that the LRA gives you, that you have the right not to be unfairly dismissed. And when we speak of dismissal being fair or not fair, the law says that yes, this right not to be unfairly dismissed involves a two parts to it. That you cannot be dismissed unless there is a fair reason and a fair procedure. In other words, your dismissal can only take effect if it was done substantively fairly and procedurally fairly, both of them. If one of the two are lacking, then it's an unfair dismissal. Okay, so this is the starting point that we enter, the law of unfair dismissals. That you have this already protection under the Labor Relations Act, and no one can simply dismiss you like that. It's very common, that you take up a job and they ask you to sign a contract, and the contract says has a clause like this. Either party may terminate this contract on 30 days notice. Right? So there's a clause there called termination, and it says either party may terminate this contract on 30 days notice. So if your employer, if you've been working for a couple of months, and your employer says to you, thank you, here's your notice, at the end of the month, it will be your last day. It's the first today. At the end of the month, the 30th, it's your last day, it's your 30-day notice, and we'll pay you what we owe you. Is there anything wrong with that? The contract says either party may terminate the contract on 30 days notice. Your thoughts on that? No thoughts on that? The contract says either party can terminate this contract on 30 days notice. You've been working for some time. The boss tells you, look, thank you, man, but here's your notice now. Here's your letter to tell you that you've got 30 days to leave, to vacate, and contract will be ended. It will be your last day. We'll pay you whatever we owe you, outstanding leave, and all this and the other. Okay. How would you take it? Would you say, well, okay, yeah, the contract does say, 30 days notice, and yeah, okay, I did sign for that.
But
telling me to go.
Sorry, but is there a fair reason? Is there a fair reason for that? Because I mean, that sounds procedurally fair, but what is the reason for the dismissal?
There you go. That's at the heart of the problem. That's the heart of the whole issue. That a dismissal, that in fact is an unfair dismissal because it has to be substantively fair. There must be a reason for it. So the mere fact that you give me notice, and what is the law considered to be fair, substantively fair?
Ryan, on that point, Is that contract in the first place, Ryan?
Yes, yes, yes.
Can I ask, is that contract in the first place, was that contract a legal contract to sign? If there is a clause like that in.
That is another good point. That despite, that may not be, you see, it's a question of interpretation of a term like that. A term like that must be, made clear to both the employee and the employer that it doesn't simply mean that I can give you notice now. Despite that being the case, it wouldn't be an enforceable clause, basically. So you're asking me if it's lawful. The question is, it's a term, but it cannot be enforced because one has the right to not be dismissed unlawfully. And this means that an employer can only dismiss you for substantive reasons. In other words, there must be good reasons, substantively fair, and procedurally fair reasons. So your question that is it lawful there? It's highly questionable, and it won't be enforceable. Okay, because what would happen is that person can refer the matter to the CCMA, and the CCMA will ask you, were you employed? Yes. Were you dismissed? Yes. Okay. Now the employer must show. The onus will change onto the employer to show that though the dismissal was fair. Now, what does the law say? That it's not impossible in law to dismiss somebody. This is what the other extreme we must avoid. That people tend to think the rights are so much on the side of the employee, which is true. But the employer may dismiss you if there's a good reason. And what are considered to be good reasons? What are considered to be good reasons for dismissal?
In this case, I would say
yeah, okay, yeah.
Okay. Well, basically for me, I would say in this case for Jack coming to work, still hangover, intoxicated, that would be a good reason for him to be dismissed after obviously previously been given warnings, maybe, and then obviously been put through a normal disciplinary hearing where he would give a chance. But then also maybe the work and maybe help him if he have an alcoholic problem, because I know that if somebody does have a problem with alcohol, the employee must first help the employee before he can just go and dismiss him. I don't know if that is still correct. That is what I heard somewhere.
Yes, no, you're correct there. So we're building up the whole thing here now. But keep that point now. With Jack, the question to us, the first question we were asked to answer was, is there good enough reason to dismiss the man? Do you think Jacob's employer had a reason, a fair reason to dismiss him?
If you answer, short answer, my answer would be yes. Because of his intoxication and coming to work drunk every day or every second day.
Right. So on the face of it, it appears that there is, because the Labor Relations Act, now we must work in terms of labor law now. What is considered to be a fair dismissal? Is grounds of dismissal. Who can tell me what they are? Well, the first one is this: misconduct. This is the most common reason why people are dismissed in practice in the workplace. Misconduct. What's the second one? Incapacity and operational requirements. and operational requirements. This is what the LRA recognizes as substantively fair grounds. Whatever you're going to dismiss the person for must fit in basically in these broad categories as your substantive reasons. Right here. So what Jack did here would qualify as what? Misconduct, not so? Some form of misconduct. If you come to work drunk, that is not proper. I mean, it's acceptable that when you come to work, you need to be in the state to be able to carry out your duties. But if you come to work half drunk, you're not able to do your work and you could endanger the lives of other people at work. So that's misconduct. Now, many things qualify as misconduct, right? But in terms of the LRA, misconduct is any rule that the employer has put in place in the workplace, which everybody knows about, and it is applied consistently to everybody, and which is also reasonable, right? Must be a reasonable thing. It cannot be something that is too sort of, inconsequential. It has to have certain levels of seriousness to be considered an act of misconduct. Drinking on the job, stealing, coming late, insubordination to your employer. So there's a broad, books are written on just misconduct dismissals. Okay, so there's a particular way to deal with it. The other basis upon which is substantive fairness is based is incapacity. And this is also another way. The incapacity, the reason for dismissing you is because two kinds of incapacity. The one is because of your health, right? It can be short-term or it can be long-term health problems. And on the other side is your competence level, your ability, right? No matter what you try now, this person can't do the job. Okay. And then thirdly, the operational requirements. This is the ground where something has happened to the employer, technologically, economically, financially, structurally, or of a similar type problem where the employer is saying, look, I can't continue to employ you, and therefore I need to dismiss you, I need to let you go. So with operational requirements, it's not a simple thing. The law requires the employer to, depending on the size of the employer, okay, you get different levels. Employers with 50 or more, or 50 less, 50 more, 100, 200 more. And the more employees you have, the more you need to intensely consult with your employees. The employer has got a duty when he starts to see that, okay, we're going into trouble here, I better start to talk to my workers. I need to speak to my employees that, look, we're not going to make it. We may need to consider downsizing. We need to consider many options before we ultimately decide to let people go, to dismiss people. Okay, so that is possible for the employer. Incapacity, the same story. It depends on if it's based on health or it's based on ability. That the employer, our punishment to, dismissal is a form of punishment in the workplace. It can be that. And therefore, our system of dismissal is progressive. Our system of punishment in the workplace is progressive discipline. And people, we know the government realizes, and that is why it gave all these rights to employees, the right to all these things that we've mentioned already before. And therefore, even to dismiss you is a big thing. It's a difficult thing to do. So it doesn't want to, even when you make mistakes, the law is such that they want to progressively discipline. And that also depends on the nature of the offense. Okay? Coming late once or twice is not the same like, insulting and boxing the manager, kicking him, or stealing from the employer, right? It is not the same, and they all will have they're all considered acts of misconduct, but they have varying degrees of misconduct that apply. So very importantly, these are the three basic substantive reasons or that you can dismiss somebody in terms of the LRA. And it all involves a problem on the side of the employee. Misconduct, you did something wrong, it was considered wrong, and you knew about it, reasonable, and yet you did it. And, depending on the type of act of misconduct, you were also given warnings and chances, but you did it. Some acts of misconduct don't even need many chances, right? If the manager catches you stealing money and he catches you red-handed, or they've got, good evidence of it, there's no need for, it's up to the boss really, it's up to the employer really to decide what will become of you ultimately. But as long as they now have to follow the proper procedure as well. If the boss has caught you stealing or committing a very serious act of misconduct, that is the substantive side of things. But as angry as they are, they must still afford you an opportunity to present your case through a disciplinary hearing. And if they fail to do that, then that person can take you to the CCMA and say, well, I was unfairly dismissed. And they will say, well, yes, I did steal, or I did do this and did punch the manager. But we chased him away and we didn't have a hearing, and that would make the dismissal unfair. Okay, by virtue of failing to comply with the procedural aspects of it. Okay. There's also another kind of dismissal. These are the three main ones, but there's a further one. Can anybody perhaps tell me what that type of dismissal is? It's a very different kind of dismissal to what we see here. Hey guys. Has anybody heard of a term known as constructive dismissal? No one's heard of this? So this is a bit different to the normal way. You see, in the normal grounds of dismissal being misconduct, incapacity, or operational requirements, everything came from you, the employee, in the sense that the fault seems to be lying with you, right? And the law protects you. You are an employee. We go to the CCMA. If you get dismissed, you can take it to the CCMA. The CCMA will ask you, okay, are you an employee? Yes, there's my contract of employment. Or there's presumptions that go in your favor in terms of the LRA and the BCEA. Right. Number two, did they dismiss you? Yes, here's a letter telling me I'm dismissed. Okay. Then automatically the employer must come and show that the dismissal was fair. Okay, that's how it operates. Now, what happens if you resign from your work tomorrow? If you resign and you say, well, you know what, I'm tired of this place, so I'm resigning, and you give your letter of resignation and you go to the CCMA. They're going to ask you, okay, are you an employee? Were you an employee? Yes. Were you dismissed? And now you produce your letter of resignation, and they can't now classify you as having been dismissed. Right? They can only say that, well, no, you haven't been dismissed, you actually resigned, and therefore we're unable to assist you. And if you insist, then the employer, there's no duty on the employer to show that the dismissal was fair, because they will argue that you were not dismissed, you left that of your own accord. But what happens if you at work and you leave the work, you resign from the work, not because of your own misconduct or incapacity, or because of an operational requirement reason, but because the employer is doing something that makes it unbearable for you? What happens if it's a lady that's working as a secretary and she's being sexually harassed at work, and she's fending off the person's advances at work, but the person won't listen and she can't take it and she leaves. Now, if she goes to the CCMA, they will ask her, did you leave? Then were you dismissed? No, I left. So is that fair then to that lady, to a person in a situation like that? No, right? Obviously not. So this is where, you know, the Labor Relations Act defines a constructive dismissal under Section 1865 that it is when the employee resigns or leaves because the employer has made further employment or further working for the employer intolerable, unbearable. Okay? And then what you could do is you can resign and you will refer it as a constructive dismissal to the CCMA. And you would then have to show the CCMA how the employer made it tolerable for you to make the employer liable for this unfair dismissal. Any questions on that? No. So,
Ryan?
yes, Mr. Van Renen.
I actually have a question on that.
Yeah.
As was my case I think about 3-4 years ago, whereby the work also made it intolerable for me to stay longer on. But that time, I was informed that if I resign, then I would lose my benefits from the UIF because you only need to be fired. So I eventually had to resign because I needed the benefits from the UIF.
Just 1 second, Mr. Van Renen, hold on. Okay. Mr. Van Renen, 1 second, you're just breaking up a bit. Can you just say that 2 years ago I heard you when you said,
okay, basically it's just about
2 years ago they did something and it forced you to resign. What did they do?
Okay, it's a it's a long story, but anyway, the point is that I also resigned because of intolerable working conditions that was later on put on me. That time I was advised that you couldn't benefit from the UIF if you resign. I mean, if you resign from work, your employer must actually fire you in order to get the benefits from the UIF. So then I did something so that I can get fired in order to get the benefits from the UIF. Can you hear me, Ryan?
Yeah. Mr. Van Renen, I'm very sorry, man. You know, your quality, man, you broke up a bit there, man. Just 1 second, I'm gonna see if I can. Okay, man. So just I kind of missed you there.
I just wanted to find out, Ryan, just for clarity for my mind's sake. Like you said, constructive dismissal is you as the employer, I mean the employee, you have to resign. Right?
Yeah.
Okay.
Yes.
So what I was that time I was advised is, should I resign, I won't get benefits from UIF. Okay. So what I then did was I did something stupid so that I can actually get fired in order to go and claim my UIF money. Can you hear me? Does it make any sense what I'm saying?
Yes, I can hear you. Yeah.
Okay, so I just want to find out, can that still be taken as a constructive dismissal? Because there's a lot of situations like this where people actually they are afraid of resigning because they won't get the benefits from the UIF. So they rather stay out of work so they can actually get fired in order to go claim the money from the UIF. Okay, that's basically what I want to know.
Wow. Okay. I would say, look, the thing is, if you are confident that you can show, you know, the CCMA that, look, I didn't want to leave there. The employer made further employment intolerable for me. In other words, and made it very hard for me to continue. No reasonable person would want to continue, and therefore I left. And when you know, UIF is a different thing. UIF is when you become unemployed. You know, the UIF will not investigate sometimes too much how you became unemployed, but although resignation could raise a bit of a problem, because you are the cause of your own unemployment. But if you show the UIF that, look, you know, it was an unfair dismissal, I was constructively dismissed. Right? I left because I was dismissed here because I couldn't take it there, and the CCMA even agreed with me. And you must try whether the UIF will actually still entertain such an application for unemployment benefits, but you can't get unemployment benefits either way if you get another job. Right? So if you leave and you start another job, you cannot actually lodge a claim with UIF because you are now employed. The UIF is designed only to help you through that difficult time where you are looking for another job. It's not meant to be a long-term help. It's only meant to be short-term help, like a few months. Get you through a hard time so that you can at least just get another job. The minute you get another job, you are not eligible for benefits. You must register again now with them, with your new employer for UIF, and your money will be deducted every month. So it perhaps wasn't a good idea to do that, you know. The difficulties with constructive dismissal, it's all a question of evidence. Okay, you must prove that the employer made life or further employment intolerable for you. And intolerability is a mixture between two tests from the case law. You can see that some people, you know, compare it to what is objectively intolerable and subjectively intolerable. What is intolerable for you may not be intolerable for somebody else, and vice versa. Right? If you are a sort of a very conservative person and you grew up in a convent or in a monastery or something, and you work at a mechanic shop or in the construction industry where, you know, the behavior and the people, every worker swears, every second word is a swear word. All right, so for you, that would be intolerable. You can't take that. So in your subjective view, that's intolerable. Okay. So the subjective view is you can't always have that subjective view. They need to compare that. It's an objective test. You need to compare what a reasonable person in that position would have to be put up with. Okay. So sometimes people find certain things that the employer does which are intolerable to them, but not intolerable to the reasonable person, because you are required to put up with certain things. Okay. And what the case law tells us is, you know, what is intolerable is definitely harassment, you know, assault, fighting, failure to pay you, failure to, you know, those things are what the court will always ask that question: what is it that this employee had to endure? And will compare to the reason, and if it's found to be, you know, unbearable. Another thing is if the employer you've got a concern in the workplace, like a grievance, and the employer, you asking the employer to look at it and look at it, and it goes on, and the employer ignores you and doesn't help you. You know, two options that you could do. The one is you could you know, resign for this reason, that look, I can't be put up with this because they don't want to help me in my problem. Or what is the other thing you could do when the employee is not fighting, but they are keeping you on under hard conditions, bad conditions? What else could you do? Guys, I'm having a bad line here. Can you hear me? Can anybody hear me?
Rayan, I can still hear you.
Can't hear me.
I can hear you, Rayan. Can you hear me, Adele?
Okay, it doesn't seem to hear me. Sorry, who's that? Is that?
It's Adele. Can you hear me, Rayan?
Okay. Hi, Adele. Yes, I'm just having some network issues here.
Not.
Can you can hear me then?
I can hear you. Let's just check. Students, can you hear Rayan?
Okay. Yeah.
Drizzle, does that mean yes? Okay. It seems like they say yes.
Yes. Some of them
Yes, I
are
can
saying
hear.
yes. Okay.
Okay, thank you.
Okay. So here will be about the constructive dismissal issue. Were you going to say something, Adele, or are you just checking in? Oh, okay. So the test that the courts look at is it is an objective test for constructive dismissal.
I can't
Okay.
hear it all, my friend.
Breaking.
Yes.
Breaking.
Am I breaking up, right? Okay. I'm gonna just log out quickly and see if I turn off my router. 1 second. Okay. Are we better now? Can you hear me now, guys? Is it better now?
No, not from my side.
I think you guys can still breaking up a lot. Okay. I don't know what it is. Okay, guys. So
You sound much better now.
from better now. Okay. So the courts will look at the conduct of the person who resigned, to an objective standard to see whether that person is not really just making up stories, or is being oversensitive or unrealistic, and then it will decide whether that was intolerable behavior or not. Okay, because then anybody could resign and then claim that they were constructively dismissed. It is open to abuse. So, but like I mentioned, that is one option. The other, yes, Tozel, were you saying something?
I wanted to ask, can emotional abuse be a subjective or objective intolerability? Because I used to work for this woman who was very emotionally abusive, and then I left for that reason. And then it wasn't long after I resigned, 2 other colleagues left shortly after me, because we all were actually, feeling it. And then,
Behavior. Yeah.
yeah.
Yes, please continue. Yeah, and then.
Yeah, but because it was an MPO, we weren't a big office, and the board didn't believe what we said, because essentially the board of the MPO hired the CEO, and we asked them to look into it. Even though we had left the MPO, we had asked the board to look into it, and it was only with the second batch of employees that they could actually see that she is quite abusive emotionally, and I think at that stage she got very aggressive. And Then they called us
So
back
you-
for the CCMA thing, and then they dismissed her for misconduct and incapacity and all sorts of things. And she took them to the CCMA,
Oh,
and there was supposed to be an arbitration. We were asked to be witnesses and testify to the abuse. And then when she saw us, she decided to just mediate instead of going through the arbitration. So, but for me, it was just interesting. I never knew about this constructive dismissal. If I knew, I maybe would have then gone to the CCMA and said, you know, it was really intolerable to work under her. So yeah, and I don't know, does the LRA apply also to MPOs? Because I feel like
LRA.
yeah, I feel the MPO sector, they take a lot of chances because it's not very big offices most of the time. They're quite small, maybe 5 to 10 people. And in an office, sometimes, I mean, we were only 4. And
The NPO can be
yeah,
taken to the CCMA.
yeah, I feel like in the MPO sector in general, you know, the employees don't realize that they are protected under
Yes,
labor
of
law.
course.
Yeah.
Okay. Yeah, can you just give me a second? I want to make another plan here to go closer
Okay.
to the. Just excuse me for 1 minute. I will get to a better connection. Just 1 second. I can't hear you guys. Okay, guys, can you hear me now?
Much better, yes.
Yeah. Okay. Thank you for your patience there.
No
All
problem.
right. So I'm sorry. Your question before I left you, before you broke up so badly, Terzal, was: can NPOs be taken to the CCMA?
Yes, especially the board. I mean, in my situation, I found the board was very uncooperative. They tended to believe the CEO more than they believed us, even though all of us as employees basically said the same thing. But she had this little black book or these files where she basically would write every single day, every bad little thing that we did. And it was really bad. So they never believed us, even though we said to them, even though we resigned and left, you know, I even emailed the chairperson of the board and said, you really need to look into whether this woman is able to actually be your CEO, because she is emotionally abusive, and you know, the ethos of the NPO, you know, she wasn't living it out and all this other stuff. But anyways, but my point is that, is it possible when you're in an MPO setting and you as an employee, do you take, and you find that your employer who's the CEO, who's employed by the board, do you take the board or do you take the employer or the organization in itself? I mean, who exactly is then the boss there? Because I've always found it a bit difficult in the NPO sector. You know, you get always a board and then you get the CEO, and the two of them usually work together. But I mean, the people in the lower ranks, how does it work? And it's always been confusing to me.
Yeah. Now you see, the thing is, who is employing you? It is the NPO
yeah.
itself. It's not these agents of the NPO. Okay. This is basically, there's another doctrine in company law known as, the separation, or the company is a separate juristic person to its agents. Okay, the people that represent it. So it's the organization that is your employer in reality, not the people that represent it. Okay, and now sometimes in small companies, it may appear that the representative is in fact this company, or is this organization. But if there is a separate registration of this organization, then the organization is the party that you will take, to the CCMA or sue. And on that ground, you can take that organization, any employer you can take to the CCMA, if you are an employee and if they dismissed you when it comes to these questions. Okay. All right. So you can take NPOs, NGOs, churches, mosques, government, non-government, doesn't matter. If they employed you and they're all subject to the law, and they must follow it, and they have a duty to do so. And we, as employees, people must realize that the law really favors the workforce. The rights that the employees have in this country are, in my mind, it's very good in one way, but sometimes it can also be a discouraging thing for outside investors.
Yeah.
Right? Because they see, okay, I am from another country and you're asking me to invest in your country. Fine, yes, we can do that. But now we see that if we want to get rid of employees, all the employees have so many rights and so many privileges and things. Maybe, we'll try another country. To dismiss somebody, it's so difficult. You can't treat people, And our law is saying that that is what a decent worker, how they should be treated according to that standard set out in the labor law. Okay.
I have another question. Sorry, I'm asking a lot of questions.
No, that's the whole idea.
Something that I've been thinking about recently, that I don't know if you saw that story about that that teacher who the WCED, the Western Cape Education Department, took. They are charging him with writ for fraud because he ticked the box of, or he put on his CV that he's an African male, but he's actually, according to their thing, colored, right? But my whole thing is, shouldn't we have the right to choose our race? I mean, and then what does the labor law exactly say about that?
Exactly.
Because
now this will be a contentious issue, exactly, and it's attracting the necessary media and social attention that it should, because in terms of the Employment Equity Act, we're not you can't discriminate against somebody on the basis of race, right? But at the same time, we also legitimize discrimination, unlawful discrimination, in terms of a document known as affirmative action, a policy known as affirmative action, right? Where we give preference to persons or race groups of previously disadvantaged groups in terms of the opportunities that are afforded to them in the workplace. Now, this gentleman did do that, but his argument is that I don't consider myself to be that. So it's going to be very interesting to see how this thing is going to be arbitrated. That gentleman, what is his surname again?
I can't remember.
I can't remember now, but I did read about it in the papers and saw what it was about, and the argument from the Western Cape Education Department is, well, you chose that, or you ticked off that because you were going to get an unfair advantage, and you committed an act of dishonesty in your job application. Right. So, but his argument is, I wonder if they will interpret. It's a question of how the courts and how the arbitrators at the CCMA will interpret such a thing, or not the CCMA, at the bargaining council will interpret such a thing. Interesting to see. It's another argument on its own that no, I'm a human being. I'm a South African first, and then you can classify me later. Yeah. So
yeah, Glenn Snyman. Yeah.
Yeah.
He was the founder of People Against Race Classification. I just found it interesting in terms of in terms of labor law and what the education department as the whole administrative, why they doing this, and I don't know. I just find it weird. And the Constitution says we can develop common law, but then I don't know. It's just very confusing. But I just thought I'd ask you from a labor perspective.
No, of course, it's going to be interesting. Yes, Mr. Van Reenen.
No, it's fine, Ryan. I'm just going to unmute it and apologize.
Oh, okay, no problem. So yes, exactly right. So, but it's the country has got affirmative action targets. Certain groups that will be benefited, and so the question is, did he act in a bad way, in bad faith, in doing that? I like to see the reasoning of the courts there. Okay. And remember, there's also another court known as the Equality Court, where you can take matters like this, especially if you feel that you've been discriminated against. But labor laws, it's at the heart of many of the contentious things, especially employment equity. And no one can be unfairly discriminated against, but the court and the law does say that, yes, in terms of affirmative action, that kind of discrimination is lawful. I don't know what excuse this gentleman is going to have now, but yeah, let's see how that develops. Okay, so constructive dismissal, it's when the employer makes further employment intolerable for you, and it's an objective test. Now, we were talking about what else can you do if you are working for somebody other than resigning and which you can do. You can resign and then try and make a constructive dismissal. But what else can you do if you are working in conditions where it's not good, it's bad, it's just short action, any action that is just short of dismissal? Is there anything else you can do? Any action on the part of the employer that is just short of dismissal? That should give you a hint over there.
Suspension? Just a guess, wild guess.
No, you can take the matter up as an unfair labor practice. Remember, any unfair conduct relating to surrounding suspension or any conduct that is just short of dismissal. So sometimes, you get treated in such a way that you are just kept there, conduct short of dismissal. One could refer the matter, instead of resigning, one could refer the matter as an unfair labor practice. Okay? So there you retain your position. That's the difference. If you resign on the grounds that, look, it's an unfair dismissal for constructive dismissal, then you've lost the job in the sense you can now get, perhaps compensation and that. Reinstatement will be difficult if you've left in that place, in the sense that it's already understood that you don't want to go back. But unfair labor practice is you're still working, the conditions are bad, and there's unfair behavior on the part of the employer against you. So you can, while you're still working, for the employer, you can take the employer to the CCMA on that grounds. unfair labor practice. Let's go back to that slide and see where is it now. What am I looking at here? Not the same thing. Let's go back to Jack's question there now. What was the second question for Jack? Do you think the employer should have tried other ways to assist Jack instead of just issuing warnings? Should the employer have tried to help Jack or look at other ways to assist Jack?
Yes,
Ryan,
I think so.
Yes.
Yes, I think so.
Kenneth, is this Kenneth?
Yes,
Yes, Kenneth, go ahead.
I think the employer could also maybe put it to Jack that he probably send him for treatment. Not necessarily rehab treatment, but maybe an outside rehab, or if he's really into the alcohol thing, then maybe for rehabilitation and for a period of time, and then come back to try and normalize Jack's actions or his behavior.
Good, yes, okay. Mr. Mahaja? Okay, Mr. Mahaja, were you going to say something?
I wanted to say something that he already mentioned, that there is a lot of program like employee assistance that he can go through first before they can start the process of firing, of dismissing him.
Oh. So thank you, Mr. Smada and Kenneth, and also Terzel. This was the point that you made at the very beginning. You know that, okay, well, this person, the question wasn't clear, and the question is purposely not being clear so that you can offer your response to it. And, you know, in cases like this, where somebody is working overtime, working a night shift, and is doing work that is, you know, where they could actually suffer, their health could suffer, one must be careful just to institute disciplinary proceedings for the purposes of you know, the misconduct hearings. You know, sometimes when there is case law where the arbitrators have said, and also the labor courts have said that when a person, you know, especially if his health is at issue, or is under stress, or this, whatever the case may be, then it shouldn't be a misconduct hearing, but rather an incapacity hearing. You know, the incapacity was to look at either your health or your capability. So if it is a health issue, then the employer has to, in fact, is required to look at other ways other than dismissal. And other ways to help the person with a problem would mean, as you guys have mentioned, like counseling and trying to, you know, change the situation for him so you can help him. So instead of issuing warnings, now remember, I want to come to this point now. What is a warning in reality? What is a warning? When the employer gives you a warning, well, what is it? What kind of thing is it? What is it in reality? Isn't a warning a type of punishment also? right? The employee, you know, he has to hear, he has to in fact first find you to be guilty of something, and then you can say, okay, you know what, you've done this now, so I'm warning you, don't do it again. Okay, somebody comes to work late, you know, 1 time, 2 times, 3 times, and they warn him, they say, look, don't do it, right? And they give him a verbal warning, and then the code may say, well, you know, you must also give the person another warning, a second warning for coming late, and you must give them a written warning and a final written warning. Is like depending on what the code in the place of employment says. You know how many chances you may get for things like this. So a warning normally comes after you assume somebody has committed something wrong already. That's why you warn them. Okay, we're warning you, you did that, but we're warning you now, don't do it again. So at those occasions, don't you think that when they were, when they were investigating, when they received these complaints, should they not then have asked of him then at that time, look, Jack, what's going on? Why are you coming to work drunk and, drinking at night and that? Okay. And to work as a nurse, you guys will know it's if you're working as a nurse at night, it can be stressful work as well. Work at night, and many of these nurses, they work through the night, 7 at night till 7 in the morning, and then the next week they work 7 in the morning till 7 at night. So the employee, in fact, is obliged to look at other ways to help Jack, right? If they don't, we're going to see what will happen if they don't do it. Do you think the employer has a duty to establish why Jack frequented the bar?
Didn't we answer that sort of already? Or is that just with the warnings?
No, okay. Yes, do they have a duty to find out why he went to the bar? There is feelings they for and against it, because what the main thing behind this question is to see that many people would quickly assume that, look, this person must be disciplined. First question was, do you think they got a good reason to dismiss him? And then, some of you were not sure, but many people are, to them, it's a clear case of, no, this is bad behavior, and it warrants dismissal. Okay, and you can't be dismissed really, if you must first have a hearing also. So I think you're all right, and we did cover that to some extent. Next question. Do you think it would be fair of Jack's employer to deny him an opportunity to present his case before a disciplinary hearing?
No, I don't think it will be fair not to give him chance, because he need to be there and present his case as a person, just for him to, at least when they reach a decision whether to fire him or what, at least he presented his own case.
Yeah. Even though they gave him many warnings, they said they gave him many warnings about it.
But still, even if they gave him,
that is the thing. Employers tend to believe that, oh, but we gave this person so many warnings, and that should be the end of it. Why must we warn him again or call him to a meeting again? That's not proper. The employer must, despite the warnings given, have a formal process. Okay, it's part of procedural fairness. And more so when the code of conduct in the workplace even says so. Okay. Now, the employer must be careful here. If the employer dismissed the person, okay, without now, in this case, it dismissed Jack. What can Jack do now? If they did, now they've dismissed him under these circumstances, what can he do now?
He can go to CCMA.
Right? What can he ask for at the CCMA?
What about to be given a chance?
Okay, who's first here? Mr. Van Reenen.
Okay. On the last question, I think the procedure wasn't followed when he was dismissed because he wasn't given a fair opportunity to present his case at the formal disciplinary hearing.
Right.
Although
So that's an unfair dismissal now.
Yes. Yes.
So my question is, and Mrs. Mahada also said you can go to the CCMA. Now let's say he goes there and he can prove this, and that he was unfairly dismissed. Now what can he ask the CCMA for? What is the relief that he can get?
Yes, I think you can ask for reinstatement.
Yes. Reinstatement, a very powerful remedy.
Yes.
Imagine this, where you ordered to reinstate, and perhaps when the person was dismissed and they put a new person in charge, they employed somebody else now, and now you want to be reinstated. Can you see what effect that can have for the employer? Can have very, serious consequences for the employer if they don't treat the employees properly and an employee gets right. Now, under what circumstances can the CCMA order reinstatement? Is there anything, can they order reinstatement anytime, under any circumstances? Or is there requirements for reinstatement? Yes. Yes, Mrs. Mahada.
What about the immediate reinstatement?
Yes, we know this. We're talking about that now. My question is, are there any obstacles for the CCMA, the arbitrator, to award reinstatement, to grant reinstatement? Can he grant reinstatement under any circumstances, or are there only particular circumstances when he can order reinstatement?
I'm not sure.
Yes, Kenneth?
Well, if it can be proved that first of all that the employee was dismissed unfairly, look, he wasn't even charged, and that therefore there was no case, there was no procedure followed. But and they will probably look at whether though there is the breakdown between employer and employee is of such a nature that they can still work together, or if they can't, and sometimes the commission would maybe say, I'll rather grant you compensation other than reinstatement, because the relationship between the two of you, employer-employee, has been broken down to such a degree that reinstatement will not be good for either party.
Yes, very well said. That in fact the LRA says that the arbitrator must grant reinstatement. That's the first remedy he must actually do. So we are more concerned about giving the people's jobs back. But he cannot do that in a case when the employee doesn't want to work there. Right? The employee doesn't want to go back. Or the employer is saying, look, things have broken down now between us so badly that, I can't be expected to continue working. If it was somebody that was an accountant and he worked for a company in the finance department and he was stealing money, and there was, procedural unfairness. In other words, it would have been fair, but for the procedure, reinstating him back into that position now would not be in the employer's best interest. Not so. So, employer can raise this point. But however, in large organizations, large employers, especially hospitals and government departments, it's hard to say, that the relationship is broken down between the employee and the employer to such a degree that, they can't be reinstated. So many times, especially in government departments, large ones, and also depending on the type of the job, the arbitrators would rather, and judges also rather, would award reinstatement as a first prize because it is worth more to the employee and it's better for the employee to remain employed. Okay. Just try and find another slide. So are there any further questions on that? No?
No, I want to know,
Yeah.
Ryan, if does this apply also to grounds for incapacity and the other one? What is it called again?
Operational requirements.
Yes, I mean, in terms of this now.
Yes. Remember, we said that substantive fairness means there must be a reason, right? And the reasons are either misconduct, incapacity, or operational requirements. But misconduct hearing and an incapacity hearing is different approaches to it. Misconduct, yeah, because misconduct is you did something wrong. You did something wrong, right? Whatever you did, you broke a rule. Incapacity is not so much your fault, right? Imagine you work in an office and you've been working there many years and now you develop a sickness and you can't do that same job anymore. Right, so now what must the employer do? Some employers, so like I told you, there's two kinds of incapacity. The one has to deal with health incapacity, or the other one has to deal with your ability, your competence level.
Okay.
Now, what must the employer do now? Let us first see. So if it is a health issue, many employers have what we call policies in place to deal with it. Okay, that they will say, look, this is what we will do if you have become sick. And there's case law saying that the courts, if you got sick or you got hurt because of the job or due to the job, then the employer must really go the extra mile for you now. All right, to try and assist you. If you work in my factory where you working as a machinist, you cut wooden boards every day, and you've been cutting these boards for years and you lose a hand or a finger now because while doing that, there's various ways to address that, right? Like, of course, you can put in a COIDA claim, workman's compensation claim. You can now say that, look, I'm incapacitated, I can't do this particular job anymore, and the employer must look at various ways other than dismissal. So if it's a health issue, there's two broad distinctions. Is it a short-term health or a long-term health issue? If it's a short-term health issue, there must be a policy to say, okay, look, we'll cover this person for his short-term benefits and pay him, like perhaps the leave while he's on this particular while he's off. All depends what the policy says in the workplace. So you must also prove your case. Some people like to be what we call medically boarded.
Yes, no, I know that.
They not suffer this ailment. So you're going to have to show that, look, it's because of this thing that I'm suffering from.
Now, I'm just asking because couldn't one maybe say that with this specific case with the alcohol, maybe this guy was driven to alcoholism And that's a health issue.
That's the whole point. I think I've mentioned it before, yes, that it could very well be that even at this disciplinary hearing that you have, they hold the disciplinary hearing and he says, look, I'm an alcoholic. I never was an alcoholic. Since working night shift and, going through this situation, I developed this drinking habit here because there was this pub here, whatever the case may be, and I became sick and became addicted to alcohol through that. Then they would have to treat it differently as an incapacity hearing.
Okay, but does that happen during the warnings that's given, or does it happen during a misconduct hearing and then they change it to incapacity hearing, or like when does that?
That is why the question asked: should they go find out why he's going to the bar, the system? And then I did mention that when the person gets a warning, the warning should be they should have used those occasions when they decided to warn him to investigate what is actually going on, and then they could have had better direction, right? If they had asked and queried and investigated at that point, then it would have become clearer what his true problem was.
But then, what if he didn't decide during those warnings to say, and only at the last minute realized, oh, but this is affecting his work, and then he decides.
Doesn't say, then it will mean now then it will make his case that he's got an alcoholic problem not sound so probable anymore.
Okay. Right. So it's
better to the question of the evidence now.
Yeah. Okay. All right. So okay, now I was just wondering about that now. Because it's quite a I find this work difficult. I'm gonna be honest, like, because I'm always thinking about what if this and what if that, and I never know always how to apply everything.
Yeah, no. Did you try and book a session or something? Because I did try. I will respond to you. I've been trying to figure out how this thing works on Teams. So.
Okay.
Respond, okay? Then you can book a session, discuss those issues.
Okay. Thank you.
Everybody else is also welcome to book a session. For whatever assistance they need here. Okay. So the whole point of the exercise was for you to understand that what may appear to be a clear-cut misconduct hearing can very well end up being an incapacity hearing, depending on the facts and the circumstances. Okay. You may get a friend coming to you, saying, gee, I lost my job, I got dismissed because of drinking alcohol. And then he says to you, look, I have this problem, and it could change the whole thing. Okay. So even if it gets referred to the CCMA, and there you raise the point that, look, these people didn't consider my problem truly. They were just interested in punishing me and taking me to book for the mistakes I made and didn't give me a chance to explain my true problem. I actually have this illness and I deserve to be helped. So incapacity for, hearings, like I say, the employer needs to go out there to help the employee with health issues also. Some of them take out special insurance and special programs to help employees who get sick on the job. Right, so they can become medically boarded. So they even pay at part of your salary while you are boarded, meaning that you're not employed anymore, but yet they continue to pay you, until retirement age. So these kinds of benefits are good if you for big companies, for government, if you work for them. The other thing is incapacity based on your ability now, your inability. It's a bit different now. It's also an incapacity, but it is not a health issue. It's because of your competence level, right? So you hire somebody to do typing for you, and the person is required to type at least, 45, 50 words per minute. You get them on, and now you realize, okay, they can only type 25 words per minute. And you need a person to type more. They didn't. You didn't ask this. You didn't clarify this when you hired the person. So now you basically have to help such a person. Okay, you need to like find ways where they can improve. So that would involve various ways. You can't just dismiss them for not being able to do it. You need to look at ways that, okay, let's send you for training. Okay, and if that improves, the problem is solved. Or, gee whiz, this person can't do typing, but is there any other position in the company you can give? So the employee needs to look at all these kinds of avenues, explore all these avenues before they actually decide to have you dismissed, have an incapacity hearing on that. Okay, guys. So is there any? Yes, Mrs. Mahada.
Did I raise my hand?
Yeah, I see your icon is going on here, so that's how I know someone wants to say something.
No.
Okay. Okay, fine. Look, guys, you're welcome to book. Thanks, Terzel. I will get in contact with you regarding that, okay? For those people who also want to book, there's that link there in the chat box where you can click on, and you can then book a session with me, and I can assist you with your problem. Okay. Kenneth, you were saying something.
No. I am fine. I said thank you.
Your hand is up.
All right.
Okay.
Let me lower.
Okay.
it.
So, so what you can do is you can book a session with me, and then before next week's class, I can chat to you and you can have a session. Okay. Not many students. I don't know why, but that facility is there for you guys. Terzel is saying she's having issues with certain parts of the work, and that's exactly the reason for these one-on-one sessions. Okay, where you like can't make sense of something or you have difficulty, and I can see where I can assist you. Okay, so make use of that, guys. Click that session form there, and I'll get back to you. But for now, that's my time. I shall see you around. Thank you. Have a good evening.
Are we done for the day?
You too.
Done for the day, Mrs. Mada. Well, you can book a session. Like,
No,
you see that.
I'm asking because I thought maybe I thought I saw 7:30 somewhere.
Yeah, no, it's 5:30 to 7.
And then this 7:30 on the invite.
Is it? I don't know which invite you got, but I don't. Let me see what invite you got.
Yeah,
It's
the
also
same
my
7.
invite. Every email that I've gotten has said focus 15
2 hours, huh? Yeah. No, it's from these sessions are from 5:30 to 7 o'clock.
Are we going to get to have maybe chance to go through to get revision for exam?
Of course. Of course. I have some past papers which we will go through. But now my point to you is why wait till then, that will happen. But if you need more urgent help or some other aspects of the work, you can book a session and we can go through those parts if you like.
Okay.
Okay.
Thank you.
Thank you. See you guys. I'll get back to you, Terzel. Okay.
Okay, thank you. Bye.
Bye.
Bye guys. Bye guys.
Bye.
Uh,
Bye.